Hello, everybody, and welcome to this special edition of MacroPro and Friends. Today is the 1-year anniversary since our last in-person conference, and that very evening, our state called a shelter-in-place order, and we have been sheltering ever since. We thought we would commemorate this with a full-day conference of webinars. So we're so happy that you're here to join us. I'm Diane Cohen. I'm the Vice President Client Services for MacroPro, and I'm in charge of the Education Department, and we hope that you have been able to join us for more than one of these classes today. So MacroPro is a document retrieval company, and we help attorneys and claims people with gathering records for their claims and litigated files. So regardless of where you have records, nationwide, worldwide, MacroPro can assist you in getting those records. Today, I am joined by Stephanie Lee. Hi, Stephanie.
Hi, Diane.
How are you?
I'm doing well, thank you. So happy to be here with you today.
I'm glad to hear that. So tell me, how are things for you and for the law firm since the pandemic hit?
Yep. Things are going well. It's definitely been a challenge, but there's been many blessings within that as well, such as we were able to move our office. We actually got a bigger space, so we're very excited. We moved our corporate office, you know, we're able to maintain all our staff throughout the pandemic, and we're just so blessed, and we're just pushing through.
Oh, I am so glad that things have worked out well for the firm. I have a little bit of housekeeping to cover. And so regarding housekeeping, that I want you to know that your certificates will come to you tomorrow via email. It is important that you are logged onto the system, not that you are just calling in. If you're just calling in, there's no way for GoToWebinar to track that. So you must make sure that you log in order to get your certificate. Unfortunately, MacroPro does not get a copy of all the certificates. So when you get your email, you want to make sure that you download them so that you have it for your records. If you can't open it for some reason, go ahead and send that to me. I'll open it and I will send you a copy for your records, but we can't generate something for you. Handouts are attached to this webinar so that you have them for future reference. So please make sure that you download all the information while our speaker is online. And then lastly, there'll be an encore performance of this on the MacroPro YouTube page. So be sure to check into that. So Stephanie, tell us a little bit about your speaker.
Yes, thank you. Today we have John Shetler, and he is an associate attorney with our Escondido office. And John graduated with a master's in physical therapy and worked as a rehabilitation director for 10 years at a skilled nursing facility. Now, he was providing physical therapy to both the residents as well as the injured workers. Now, after 10 years of that, John decided to go back to campus, and he obtained his law degree in 2002. And that's when he began practicing workers' comp. With John's medical background, it has been extremely beneficial to his practice of workers' compensation law, especially when reviewing medical reports and deposing medical experts. So a little bit about our firm. We are a boutique litigation firm, and we have 3 offices in California. And we have been practicing workers' comp defense since 2005. Just a little bit about us. And now I'm going to turn it over to John for the presentation. So John, take it away.
Well, thank you, Stephanie. It's an honor and a privilege to be here. You know, especially to talk about a subject that's really affected everybody. You know, so many people in the last year, and that is COVID-19. You know, in fact, the reason we're doing this here via webinar is because of COVID. I'll be honest, this is my first time doing a webinar as a speaker. So I talked to my wife, who's a school teacher. You know, she's been doing Zoom for the past year. You know, I asked her for some advice, and she told me, you know, hey, don't try to be too funny. Don't try to be smart. Be yourself. So I'm not sure if she was insulting me or giving me advice, but hopefully I can give you something that you can take from this conference and apply it and better manage your COVID-19 cases. In order to talk about where we are and how to manage and defend a COVID case, I just want to start and go back, talk a little bit about how we got here, you know, what laws there are, how they apply. Then we'll get into the nitty gritty and what we're here for, which is how to defend a case, how to limit our liability, and then ultimately what to consider when we're settling the case. On my notes, I have down to put a COVID joke in this spot. I decided not to because I didn't want to wait the 14 days to see if you got it. I know that's a bad joke, but that's as good as I get. All right, so the history of COVID presumption. We know a year ago, everything, stopped. Actually, for me, it was a year ago to this date. I was at a high school volleyball tournament. The NBA stopped, and then the next day, school was canceled, businesses were closed, and life as we know it turned upside down. Who would have thought that the old saying, "I wouldn't touch you with a 6-foot pole," would turn into our national health policy? But here we are. It's been that kind of year. In response to the COVID pandemic, some laws were passed. Because some people did have to work. There need to be laws to protect them. We'll go over those laws just really quickly because I know you've been dealing with them for months now. We'll touch on the differences, but more importantly, once we get past that and everybody's on the same page, we'll go ahead and talk about how to defend the workers' comp case. All right, the first in March 19, so about 51 weeks ago, Governor Newsom here in California issued the executive order. Was limited in time and scope. It only ran through July 5th. There were some constitutional questions regarding did the governor have the power to issue this executive order. Important things to take note from the executive order: it created a presumption. Luckily, it's a rebuttable presumption, but it created a presumption, and it limited our time to discovery from 90 days down to 30 days. So those are, we've been dealing with that, but just to reinforce that. The state bill came along in end of September, was retroactive to July 6, running through January of 2023. The state bill, for the most part, codified the executive order, but it did a couple things different. It created 2 subclasses of employees that may qualify for the presumption. It's not just everybody that was working. Now we have first responders healthcare, more the frontline workers, and we had an outbreak exception. These are covered in Labor Code section 3212.86 through 0.88. A couple of important things to consider when you're dealing with a case. If it's a first responder, read the Labor Code section. It lists the penal codes of who they are considering first responders. Make sure your employee is considered. When they wrote the statute, it specifically says it's primarily for firefighters that are actively engaged in firefighting and law enforcement officers that are primarily engaged in law enforcement. So know what your employee was doing during those 14 weeks. If they were working as a dispatcher, well, I'm not sure the presumption applies. If he was riding the desk or she was riding a desk for those 14 days, again, I'm not sure the presumption applies because were they acting primarily, out enforcing laws? So very important, talk to your employer, find that out. Outbreak exception. If you get a claim coming in that's not a first responder for healthcare, check your numbers. The employer should be reporting this to you. They should be reporting their employment numbers to you. Check that. Make sure you're not in an outbreak situation where you either have 4 tests out of, if they have 6 to 100 or 99 workers, or you have more than 4%. Significant differences between the state bill and the executive order are that they broke up, instead of just a 30-day decision timeline, like we had, for everybody under the executive order. Here, the frontline workers get the 30 days, while the outbreak, they're generous and gave us 45 days. Now, again, I'm not a mathematician, but this is either a third to a half of our normal time. So not only are we being hit with a presumption, we have a third to a half of the time to overcome that presumption. Another significant difference between the executive order and the state bill is the viral testing. The executive order allowed for antibody testing. Not sure why we were looking at antibody testing for past infection when we're supposed to be dealing with something in the 14 days, prior to the test. But make sure that it was a viral PCR test. Make sure the proper person read the test. So here are the labor code sections and briefly what they entail. Again, if you're dealing with any type of law enforcement officer, check, make sure that they are the ones included in the presumption. And here are the two side by side. Again, just make sure, find the dates, what group do they fall in, and once you know the dates, are they in the executive order, the state bill, then go ahead and you can work out the rest. All right, so we've been talking about presumption. It's important to just discuss what is a presumption. A presumption is a rule of law, so it's just legislative made, that if all these facts are met, then legally it's true. Doesn't necessarily have to be true in reality, but legally it's true. In the case of, for instance, the executive order, if you worked outside, at your employers, you test positive, within 14 days of that work, well, you've met the facts, it's true, unless there's two types of presumptions. One is a rebuttable presumption, and this allows us to overcome or prove that legal truth, in fact, isn't true. The other type of presumption is a conclusive presumption, and all this means is once all those have been checked, it is true. No matter if you show evidence that it's false, it doesn't matter. It is what it is. It's true. And as we discussed, the presumption acts to shift the burden from, in our case, the applicant to the defense. So instead of the applicant having to prove the injury, we have to disprove the injury. So, when we're talking about COVID, COVID is a virus, the novel coronavirus. There's nothing in the AMA guides showing impairment for a virus. What we're really looking at is what damage is it doing to what systems of the body, and that's where the compensable consequences come in. And I'll be honest, those are the really scary things that I see from COVID, or the novel coronavirus. Right now the CDC has 55 potential long-term effects, and this is on very limited data. A year from now, that could be 155, could be 555. Just the unknown is what is really scary here, because some of the things that we do know that they're saying it can cause are pretty severe. Obviously the pulmonary aspect, this is a respiratory virus. The pulmonary aspect is expected, but there's so many others that maybe you weren't necessarily expect out of a virus. Circulatory, not only does it cause hypertension, but it can cause leaky blood vessels, which will lead to organ damage to the kidneys and to the liver. Not sure if you've dealt with a liver transplant. It's not cheap, and it's not something I'd want to be on the hook for future medical wise. We know it causes cardiac inflammation, because for the most part all viruses can do that. Some of the other things that are pretty severe, they're saying that it can be linked to Alzheimer's, Guillain-Barré. Guillain-Barré is a condition where you slowly lose all muscle control. You're still active cognitively, but you end up, for the most part, laying in a bed, unable to move any part of your body, on a respirator, and then you slowly, hopefully, get your function back. But it's not cheap, and that's not, again, a condition I want to be responsible for paying for. So it's very, very important that we mitigate our damages. And I can't stress enough how scary, at least to me, the known compensable consequences are, and the unknown are even more scary. This very well could be an asbestos type condition where 10, 20 years from now, we're finding that it's done all kinds of damage. Clinically, what I'm seeing now, for the most part, is applicant attorneys alleging on top of the pulmonary and maybe the cardiac are the COVID fog, so quote unquote, impaired concentration, impaired memory. They're alleging other subjective, hard to prove or disprove things like the fatigue, the chronic pain. And again, I think this is just more, they're claiming the low-hanging fruit because they know it can't be objectified. And physicians normally will tend to find this in the applicant's favor. So, the novel coronavirus is a very serious thing, and it's something that if we can shut down our liability, do it as soon as you can. And you know why they call it the novel coronavirus, don't you? Well, I would tell you, but it's a long story. I know. Again, I warned you. I'm a dad. I like dad jokes, and I'm definitely not a comedian. So we mentioned, you notice on the outline, I have defending against the COVID-19 presumption, and I have rebutting. The first thing I do when I get a case in is, does the presumption apply? We talked about the presumption as a set of facts that if they're found, if each one's checked off, then legally it's true. So the first thing that I try to do is uncheck one of those boxes. If we can do that, we don't have a presumption. So, know what time frame you're dealing with. Are we dealing with the executive order? Because we have to know, what boxes to uncheck. So are we dealing with the executive order? Time frame, are we dealing with the state bill? And then once it is, if it's a first responder, go through the job description, talk to the employer, find out, were they primarily engaged in either firefighting or law enforcement. If it's a healthcare worker, again, find out what they were actually doing. It could be they're in an office somewhere not actually engaged in patient treatment. It could be that they worked in environmental services. And if you're a janitor in environmental services, you're cleaning the emergency room, or you're cleaning the pulmonary treatment room or ICU, well, you're probably going to qualify, okay? But you need to know that. If you're a janitor at a hospital, but you're cleaning some administrative buildings on the other side of the campus, well, guess what? You're probably not going to apply for the presumption. So again, talk to your employers. If you can take them out of one of those, first responder categories, perfect. Much easier being back in a normal workers' comp case where the burden is on the injured worker, and we have our full 90 days to do our discovery. Final thing, know if your employer is less, than 5 employees, you're not going to have an outbreak exception. All right, rebutting the COVID presumption. So we weren't able to uncheck any of those boxes, and we're stuck trying to disprove the applicant's case. We're trying to disprove that it occurred at work. What can we do? How do we go about that? Well, the key is we need to find other evidence of potential exposure. We have to do it quickly, because remember, we are dealing with 30 to 45 days of, either 35 days for the executive order, our first responders, or 45 days. So we have to have a well-organized plan. We have to do our discovery, and we have to do it quickly. All right, as we mentioned, good communication is going to be the key between the employer and the claims adjuster, the employer and the employee, especially if the employee is cooperative, between the claims adjuster and the employee. If you have a defense attorney, definitely include them. It doesn't do any good if I have a piece of information that I've uncovered and I don't share it with a claims adjuster, or if the co-employee knows that the applicant testified his sister was positive COVID and he's been around his sister, but that information never gets to the claims adjuster or gets to the defense attorney, it doesn't do you any good. So make sure the lines of communication are open. Make sure in early, and here I have employer, and this is employer and claims adjuster, investigation is key, especially given the shortened time period that we have, either 30 or 45 days. I would come up with a checklist that I would send to the injured worker and have them fill out, have him answer all these questions. Another good place to know this, that would have this information, is the employer, the co-employees. They're around, your employee all day long. They would know if he's had prior COVID symptoms. Maybe he's missed work prior to our alleged exposure. They may know that some of his family members that he talked about may have been exposed. They may know if he's, previously tested positive. I've seen cases where an employee tested positive. They went off for their 14-day quarantine, which is, what most of the cases we're seeing, right? They go off 14 days, then they go back to work and you never hear from them again. But I've seen where in those cases, and then something happens a short time later where there's another potential exposure and they're tested and it comes up positive. I've talked to doctors in those cases and they've said, well, the positive is probably from the first exposure where they tested positive originally. That is important to know. What if that first test, the first positive, was non-industrial? That's an evidence of another exposure. Help us overcome the presumption. Okay, so the employers and co-employees, they may know that. Has anybody in the employee's family tested positive for COVID? These are questions you can directly ask the employee, and you might also be able to get this information again from the employer. We've all been to the doctor. You could ask these questions. Have you traveled in the last 14 days? Have you been in contact with anybody you traveled with? Has your aunt come from Brazil that's having a huge outbreak at the present time? You need to get these answers either from the employee or the co-employee or whoever might know this. Has the employee attended any large social gatherings? At the end of the summer, I did a deposition of an applicant who was trying to tell us that all she did was go, to the doctor and back home. There's a pandemic. There's no way I'll go outside. Well, after pulling some teeth during the depot, it turns out that, well, she may have attended a couple of the protests over the summer. No, she didn't adhere to social distancing. No, she wasn't wearing a mask. That's a huge potential other exposure. All right, these super spreader events. No, and the only way I found that out was by getting in front of the applicant and asking her those questions. But if we hadn't done that, we would have no idea of the outside exposure. Again, I mentioned check with co-employees, supervisors. Since we have to gather this information quickly, they're around the applicant, they know. I always do a social media check. People put incredible things on social media, whether it's Facebook, Twitter, Instagram, TikTok, whatever. And if it's a private account, well, that's where the co-employees may come in. They may have access to it. I've had co-employees come, present me with pictures, screenshots of Facebook posts that shows the applicant working under the table for another employer. check the Facebook. Also check for the social media for, is the applicant saying things like, pray for my mother, she has COVID, or, pray for my sister, or hey, going on this great vacation, to Latin America. Know that information. If they're traveling to a hotspot, again, is it enough to overcome the presumption by itself? Probably not, but it's another piece in the puzzle. It's another, tool that we have to build up evidence to reach that point where we can overcome the presumption. Very important to gather the medical records, have the applicant, list all of their medical providers, have them sign a release form so that you can obtain those records. Remember, we only have 35 to 40 days, so we're gonna have to do this quickly. That's why, a private investigator, if there's red flags, if something doesn't feel right, a private investigator can go in, speak to the applicant, or the employee at that point, speak to the coworkers, gather all this information for you and do it relatively quickly. Strongly recommend that you get the employee statement, whether that's an interview with the claims adjuster, statement under oath, or deposition. Like the earlier COVID exposure that I referenced, only reason I found that out is because I got in front of the applicant and asked her. It can also a great source to get information about their past medical history. Another final way to obtain record, information is to get a medical examination. Now, there's certain medical examinations that we can obtain. First and easiest is the primary treating physician. Now, the primary treating physician, especially if we still have medical control, or the applicant's not litigated and it's a friendly primary treating physician, we can talk to them. There's no ex parte communication. One thing that I try to do if there's red flags on a case and we have medical control is I'll have the primary treating physician refer the applicant or the employee out to whatever specialty I need, whether it's orthopedic or neuro, psych. They can go out, get the examination done, get the report completed, get it back to the primary treating physician, and who can incorporate it into his report. And then boom, we have what used to be called an AOE-COE exam. We now have a legally admissible report on AOE-COE. Again, this has to be done quick. It has to be done while we have medical control, but it can be done, and I've done it. And it's generally been very well received and really helped our case in cases when I have done that. Obviously, the more traditional route is to get a med legal examination. If we're doing AOE-COE, it would be a 40-60 examination. A little lesser known medical examination is Labor Code Section 4050. Now, 4050 allows anybody to get a medical appointment as long as you pay for it. That's not that big of a deal for us because we pay for the examinations anyway, but it does allow us to set the applicant for an appointment with a doctor of our choosing, and she has to attend or he has to attend. The great thing about Labor Code Section 4050 is it's backed up by Labor Code Section 4053. 4053 states that if the applicant does not attend our 4050 examination, they are precluded from prosecuting their case at the Workers' Compensation Board until they attend. So it does have some teeth. You may think, well, that's all great. Why don't we get 40-50 exams on everybody? Well, the problem with that is in regulation, Section 35E, it states what can be sent to a med legal examiner, and unfortunately 40-50 exams are not included. Now, that doesn't mean that you can't get a 40-50 exam to to the med legal evaluator. One way we can do that is we could send it to the primary treating physician, have the primary treating physician comment on it, and then boom, we have a compensable, he's incorporated into his report. We can now send the primary treating physician's report that's incorporated the 4050 to the med legal evaluator. The other option is you have to file a DOR, go down to the board, have the judge rule on the admissibility of the 4050 exam. Is there probative value to it? And if he rules it or she rules it admissible, well, then you can send it to the med legal evaluator. Probably a more likely use of the 4050 exam is with cross-examining of the physicians, of the med legal evaluator. Now, I strongly recommend that we challenge the doctors either with the initial causation of the coronavirus, or more specifically with the compensable consequences. The discovery that's been done on the coronavirus is relatively new. COVID-19's only been around for a year. Most of the research has been retroactive record studies where they've gone back, looked at records of people who have had COVID-19, what were their complaints, what were their diagnoses. They just haven't had the time to do extensive research. The other thing they're doing is they're looking at other coronaviruses, seeing what they affected, and then kind of assuming that COVID-19 will do that also. But you need to be aware, we still have, especially with the physicians, they have the burden to, within reasonable medical probability. I don't know if there's, especially with the compensable consequences, if there's enough research for them to reach that conclusion. You can't let them get away with, well, they didn't have it before, but they have it now, therefore it's work related, which you see a lot in California workers' comp. Challenge them, make them provide you with the data, make you provide them with their research that they're relying on. When you get the research, then you want to make sure it's peer reviewed. You want to make sure that it's commonly accepted in the field. And then you want to review it. I once had a doctor that, sent in 50 pages of medical research to support his conclusion. Only problem was when I read the medical research, they all stated you needed these 3 conditions to come up with the diagnosis. Well, I looked at our report. We only had one of those conditions. So the doctor's own medical data didn't support his conclusions. Don't let the doctors get off easy. The consequences, potentially for future medical, it can be so severe in this case. Really challenge the doctors, make them do their job, make them prove medically why they came up with the decision that they did. All right. Well, unfortunately, we couldn't rebut it. We're now in a case where we have an accepted COVID-19 case. That brings up the question then, what do we do now? I know most of the COVID-19 cases have turned out to be, as we mentioned, 14 days quarantine, they collect from the pay bank, and they go back to work. What we don't know, and the scary thing for me is, is COVID-19 going to be like an asbestos situation where 5 years from now, 10 years from now, we find out what horrible damage the virus is doing in, the human body that whole time. So it's important that you limit your exposure, even on those what appear to be easy cases. We mentioned prior, when we're talking about rebuttal, that you need to obtain the medical records. When I look through medical records on a COVID case, I don't look just for prior instances or prior diagnoses of what they're alleging now. I'll go through and make sure that all of the known COVID diagnoses aren't listed. Okay, if they are, I flag them so that if the case, they amend the case, or if the case spreads, we're ready to defend it. Okay, and then for those known cases where they've had, they're alleging, say, hypertension, stating the COVID aggravated it. We know they have a history of prior hypertension, or diabetes, or whatever the condition may be. Compare and contrast. Take the old records. What was the blood pressure readings before? What are they now? What was the medication before? What is it now? What was the dosage before? What is it now? If there's no change, then there's no injury. And to be an aggravation, it has to cause an increase. So I've gotten out of many cases by going back and whether it's looking at blood tests or it's looking at range of motion, subjective complaints, anything that's objective that you can compare, it's better. But if you need to compare subjective complaints, then and now, do it. But anything that you can do to show that there's no aggravation, it takes a little work, takes a little digging, but get out your magnifying glass, put on your Sherlock Holmes hat and get to work, because it could save you a lot of money in the long run. All right, again, someone remediating damages, some of the things that I look at, go through the records, see if they have prior history of any of those conditions. And again, I said I check for other known COVID conditions as well to make sure that we're ready if they try to bring those in. Definitely important to obtain the applicant's statement, again, whether under oath or under a deposition. Find out these old injuries, find out all their medical providers with the applicant under oath, so that you can obtain these records. Again, there's a wide list. We're dealing with 55 potential compensable consequences now. Could be 555 in 10 years. You don't want to be stuck on the hook for that. So do your due diligence, get a complete history of their medical history, find every condition that may possibly apply, and so you can rule that out as being an injury. Again, this is more likely where we're going to need medical examinations. At this stage, where we're just trying to mitigate our damages, we're going to need probably, in some cases, more than one panel QME. We may need, respiratory, psych, neuro, internal medicine, orthopedic. Just depends on how creative the applicant attorney is going to be, and possibly how sick that the applicant actually is. Now, at this point, when we're trying to mitigate damage, may be a better use of the 40-50 examination, especially if we're looking at a potential severe compensable consequence. Like we mentioned, Guillain-Barré. You might want to have the applicant go out, be evaluated by a 40-50 examiner. You can send the med legal evaluator and the PTP's reports to that 40-50 examiner and have them review them all, and then really point your attorney and guide them on how to cross-examine either the med legal evaluator or the primary treating physician. Again, there's could be severe consequences if you don't. If there's red flags, use every tool at your disposal. We mentioned about what I see mostly is this COVID fog. When I'm deposing an applicant for COVID fog, I look for maybe prior evidence that, maybe it's just not COVID. Maybe the elevator never went to the top floor with this person. Look at work history. Were they bouncing around employer to employer every 6 months? Do they have poor grades in school? You want to examine medical history. Is there a reason maybe why they're feeling tired all the time, or they can't concentrate? Is there a thyroid issue? Are they taking any medication? For instance, are they on a narcotic for orthopedic pain? Know that can help you wipe out one of these compensable consequences. Is there a family history for any cognitive or mental disorders? Have they had any long-term drug or alcohol use that could be affecting their long-term cognitive status? If there's a PTSD, obviously you want to look for past traumatic events, abuse. One area that is hot, if you follow the news or if you follow sports, is CTE, chronic head injuries, with football in particular, but there's other sports, soccer, it's been shown, hockey. Did the applicant have any outside head injuries at any other place? And if so, were they, how many times? Were they knocked unconscious? Were they in a concussion protocol? Did they seek medical treatment? And if so, get those records. All right, another form of mitigation damage, and this is the last one that I have, is the claim form. Now, I find that a lot of employers, especially claims adjusters, are reluctant to send out a claim form. They're afraid that it's going to prompt the injured worker to file a claim. But you got to remember what the claim form actually does. The claim form starts a 1-year statute of limitations. Per Labor Code Section 5412, they have 1 year to file a claim from date of disability and date of knowledge. So give them the claim form. Start that timeline. If you don't, you may find out that you're just giving them an extra 3 years to file the claim. They may be asymptomatic now and not want to file. 3 years from now, when some condition we don't know is related to COVID pops up, they may file a claim, and guess what? The statute's been told because they never had knowledge, they were never given a claim form. When you give them the claim form, also give them the Reynolds notice or letter, advising them of what their rights are and workers' compensation. If you give the claim form, you send out the Reynolds letter, and they don't file an application within that 1 year, it's very, very likely that the judge is going to hold for a 1-year statute of limitations. I mean, judges hate 1-year statute of limitations. They want to fine for the applicant. Don't do yourself any harm by not providing these and giving the judge an easy out. All right, settlement strategies. First and foremost, a compromise and release is your friend. And I'm going to go beyond that. Not only is a compromise and release your friend, I mean, he's your BFF, your long lost pal, somebody you can't live without. With the potential exposure with COVID, if you can, close out your future medical liability. If you can't, and you're going to do a stipulation with request for award, narrow it as much as you can. Don't write COVID-19 on your settlement documents. We talked, there's 55 potential body parts that could include, and that could be 500, 10 years from now. So don't open up that liability for yourself. One thing that a lot of attorneys like to do on settlement documents is they write, especially CNR, they write, this settles all known and unknown conditions, that happened during the employment. I would, put language in that for COVID as well. This settles any known and unknown for the COVID-19. Now, most likely the applicant attorney or the judge will strike it, but nothing ventured, nothing gained. All right, so in closing, first and foremost, CNR, remember, is your friend, long lost pal. We don't know what scary things are out there in the future with COVID, so close your cases out. Don't be afraid to investigate. I had a frontline worker case, they're out patrolling, got COVID. There was no known exposure, but anyway, long story short, it turns out during the deposition that his wife works as a medical assistant. His family member had COVID, right about that same time. Those are all evidences of other exposure that could have been found out if an investigation had been done promptly. So don't just, don't be in a hurry to accept. Do your due diligence, investigate the case. Another thing we may see coming up is vaccinations are in high swing here. is compensability for adverse reactions to the vaccine. Are those going to be compensable or not? You know, I think a lot of that will depend on if the employer was mandating the vaccine or strongly encouraging the vaccine. Then I think they probably will found to be compensable. You know, then finally, you know, remember, just if we get out of the presumption doesn't mean we don't have a workers' comp case. It just means we're back in a regular workers' comp system, but with a COVID-19 exposure. You know, I'm a college basketball fan. This is, you know, normally they call it March Madness. Well, this has turned into, you know, March, April, May, June, and so on madness. But I know this is how a lot of our living rooms have looked over the past year.
Well, John, thank you so very much for your presentation and all the information inside of it. I don't see any questions for you at this time. However, there was somebody that was having some difficulties downloading the handout materials. So I want to give my email address, and I can make sure that you get a copy. My email is diann@macropro.com. That's macropro.com. And just as a reminder, we will be having your certificates emailed to you directly from GoToWebinar. MacroPro doesn't generate it, GoToWebinar does, because they track the attendance and the time and that type of thing. Since we can't be with you in person, they do all of the verification. So you will be receiving that tomorrow. If for some reason you have difficulties downloading it, please email me your original email. I'll download it and send it back to you. Well, I want to thank both of you very much for participating. It was lovely to have the law offices of Paul Herman join us for the very first time as one of MacroPro's friends. We have another webinar that will be starting in about 12 minutes, so we certainly hope for those of you who need your hours that you sign on then. Thank you, John. Thank you, Stephanie. Bye-bye now.
Thank you.
Thank you. Thank you. Bye-bye.